We will discuss some other important leading cases relating to law of contract, and among them, one is Special Secretary Finance Rajasthan Government versus BB Sesayar 1984, where it was held that an agreement enforceable by law is a contract. It must be an agreement made between two or more persons which is intended to be and is enforceable at law. It is constituted by the acceptance by the one party of an offer made to him by the other to do or to abstain from doing an act. An offer, when accepted, becomes a promise, and the term of contract denotes the legal obligation which is thereby created by one party to perform the promise and the other to accept the performance of it, unless the terms of the contract are arrived after due negotiation. They cannot be held binding merely because a ticket is a letter issued containing these said terms. There must also be proof that the terms were meant to be contractual. The said terms must have been brought to the notice of the contracting party at or before the time when the contract was entered into. If the printed terms on the ticket do not, as after mentioned, become part of the contract, they cannot be enforced unilaterally as it was held by the Rajasthan government. So, in the next important leading case, that is Sri Narayan Goswami and others versus the collector Katak and others in 1986, and the very decision was held by the Odisha High Court. So, as per the decision, a lawful agreement of lease of immovable property is a contract within the meaning of Section 10. One of the essentials of a valid contract is that the parties must be competent to contract, as far they must be competent to bind themselves by promise. So, Section 11 of the Act as defines a person competent to contract. Every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind and not disqualified from contracting by any law to which he is subject. Thus, the parties must be of the age of majority and of sound mind, and not disqualified from contracting by any law to which they are subject. Certain persons are incapable of contracting due to political status, mental deficiency or artificiality of personality as it was held by the Odisha High Court in this leading case Sri Narayan Gosai and others versus the collector and others in 1986 by the Odisha High Court. And in between, we would like to discuss one of the important leading case, and that is an English leading case, Harvey versus Fasci in 1893, and the very decision was delivered by the Court of Appeal, where the very facts of the case is that Harvey telegraphed, "Will you sell us white care?" Telegraphed the lowest cash price, and Fasci telegraphed lowest price for white care is 900 pounds. So Harvey telegraphed, "We agree to buy white care for $900 as asked for you. Please send us your title deeds." But no answer was given to this last telegram. In the judgment, it was held that there was no contract for Harvey. In his first telegram, asked two questions: "Will you sell?" And the second question: "What is the lowest price?" And Fasci in his answer did not say, "I will sell for 900 pounds." He only answered the second question. Harvey's second telegram: "We agreed to buy white care for $900 a pound," is really the offer to pay 900 pounds, and this offer, it was for Fasci to accept or not to accept. And in another important leading case, that is also an English leading case, Dayton versus Great Northern Railway Company in 1856, it was held that the representation made by the railway companies in their timetable cannot be treated as a mere waste paper. If the company promised to give tickets for a train running at a particular hour to a particular place to anyone who could come to the station and tender the price of the ticket, it is a good contract with anyone who so comes. And another important leading case we want to discuss, that is Macpherson versus Apanna in 1951. The plaintiff, who made an offer of Rs 6,000 for the defendant's property, wrote to the defendant's agent asking whether his offer had been accepted and saying that he was prepared to pay any higher price if found reasonable. To this, the agent replied saying the that the defendant would not accept anything less than Rs 10,000. The plaintiff treated it as a counteroffer and accepted it in a suit by the plaintiff for specific performance. It was held that the defendant did not make any counter offer but has merely it is an inviting offer. So, in that relation, we would like to discuss another important leading case, and that is one of the most important leading case, and that relates to Powell versus Lee, and it was a case of 1980 where certain managers of a school selected a person for appointing him as the headmaster, but they did not authorize the communication to the candidate about his selection. So it was held that there was no contract as there had been no authorized communication on the part of the managers. So the very plaintiff cannot sue the university because for a valid contract two ingredients must be there, and one is offer and the second one is acceptance of the offer. Here the plaintiff pleaded that is application for the post was an offer and the university has accepted it by passing resolution. Hence, such contract should be valid and binding. But here the court held that it was not a binding contract because there was no acceptance by any authorized representative of the university regarding the very appointment of the post of headmaster. So, this very important leading case, Powell versus Lee of 1908, was relating to the very difference between offer, invitation to offer, and acceptance of the offer.